Hi, good afternoon, everyone. This is Rajiv S. Khanna from immigration.com, the law offices of Rajiv S. Khanna PC. We do a two-weekly call every other Thursday for the community and try to answer as many questions as we can. This does not establish an attorney-client relationship, nor is it an exact answer to all the possible permutation combinations. This is not supposed to be a complete consultation. With that, I could not do a live call because I was pulled out of the office last Thursday. I'm recording this over the weekend. There are a bunch of questions. One question I have declined to answer. It is too long. I don't have the time for that. Please keep your questions short to the point so that I can spend a couple of minutes each on every question. Don't make it a question that is so long it requires a consultation. That particular individual, when I come to it, I'll point out, set up a paid consultation with our office or talk to your own lawyers. Now, the first frequently asked question that I spotted was question number, what is the number of this question? It's number 2. This is cap-exempt to cap subject H1. So he says that I am on a cap-exempt H1 with an approved I-140 more than 180 days. And there's a cap subject H1 employer who can file the H1 for them. Good. Number 1, if the cap subject H1 is approved before October 1st, will my new employment start date be earlier than October 1st? No. Because if you are going under the cap, you can never start working before October 1st. Now, there is an exemption if you were doing concurrent H1 with a cap exempt and a cap subject employer. That's a different issue altogether. I won't cover that here. But if you are going to completely transfer over to a cap subject H1B from a cap exempt, you are going to start on October 1st, no earlier. Would I have to leave my current employer as soon as the H1 is approved? No. What if I don't join the new employer until I find a project with them? This is a problem. Nobody should be filing an H1B for you unless they have a project. Okay, so I'm concerned about this question because it shows there's an underlying problem with the H1B filing. Do not have the employer file an H1B unless there is a specific project. But if there was a specific project, can I wait until after October 1st? Absolutely, but not for finding a project. That's an incorrect H1B. From your previous calls, I understood that if the new H1 is not revoked until October 1st, I don't have to go under the cap anymore. Yes, that is still accurate. Should I have to go through green card filing all over again? The answer is yes, because you're only carrying your priority date forward. Unless you are national interest waiver, EB1A, one of those two categories, you will have to start all over again. If I leave this new employer in a year, will the green card process be affected? Yeah, it'll be over. They'll wrap it up. You'll still carry your priority date, but you cannot carry your green card process until you file the 485 after I-140 approval, and the 485 has been pending 180 days. Can I start working with new employer while continuing my current employment? Well, that is possible, and that's where I said I'm not going to cover that in this set of questions. That's a long topic, but there is a little weirdness in the law. If you are working for a cap-exempt employer, you can actually concurrently work for a cap subject employer as long as it is a concurrent H1B. The implications and the ramification of that are too long for me to cover here. We have other frequently asked questions in which we have covered those, but that's possible as a concurrent H1B. Next question frequently asked, H1B revoked by the USCIS. What is the impact on the quota lottery exemption? Well, remember, if an H1B is revoked, it gives you no benefit. You're back in quota. Okay? The moment it is revoked, you have no benefit from that at all. And if on top of that there is any kind of fraud allegation against you, you cannot come back to the United States at all. That's a permanent bar from entering the US with very few exemptions. Another question. Now this one is on doing business on adjustment of status EAD and on H-4 EAD extension. So this gentleman or lady says, I know someone on EAD based on AOS must produce a valid job offer supplement J during the green card interview. Once the person updates work status as EAD, the legal status will become EAD. Can the person start a business startup while on EAD? I've covered this in various frequently asked questions before. I'll cover it quickly here. If you are the primary applicant of an adjustment of status application, you could do the business on do a business on the side. But if you take it up completely as your profession, then the job must be same or similar. In other words, you are trying to do your green card supplement J through your own business. If that's not your intention, then you must have a full-time job and you can do the business on the side. I-9 does not get submitted. Form I-9 is an internal form. It does not get submitted anywhere. Question number 2, H-4 EAD can start a business? Yes. How can the business be operating when they are waiting for extension? I do not know the answer to that question. All I can tell you is that the EAD holder cannot work actively, passively. They cannot. They just should not do anything until their EAD comes. If there are managerial level employees running the business, I guess that's okay, but you must not even answer a phone call about the business. I would be concerned about that. I think I've covered all your questions. Let's see, are there any other frequent? Yes. So if a 485 pending individual gets laid off just before getting the green card, is that okay? And in my opinion, it's okay, because there was nothing wrong with your intention to continue working. And if your 485 has been pending 180 days, I think you are very well protected, because you could have always done an AC-21 had the green card not been approved. So consider this situation. You are covered by AC-21, your 485 has been pending 180 days, I-140 is approved. And let's say you get laid off while there is still 8-10 months remaining to your green card approval date in the future. And in the meantime, you went and found a job, you would have filed a supplement J because you had sufficient time to do so. But in this situation, you get laid off just a few weeks before you got your green card. You didn't even have enough time to submit a supplement J. It's a weird case, but I think this is okay, because the date you filed the 485, you had a job, you were supposed to work here, then things changed rapidly and you got laid off just before your green card was approved. And before you could submit a supplement J, you had an approval. What are you supposed to do? So this is, I think it's a glitch in the regulations more than anything else. 4 months before you receive the green card. I think it's okay. I don't think this is going to be a problem, although it does require you to be cognizant of potential issues, but legally I think you are pretty solid. Practically, government can ask questions, but legally you are pretty solid in my opinion. Let's see. So have we covered this? So this is F1 to H1B lottery, transfer and changing jobs from employer A to B, X to Y actually. It says employer X wants to e-register me for the H1B. Okay, good. And I'm hoping to get a better offer from employer Y. Suppose I get selected to the H1B lottery filed by X. Can I start working for employer Y? Yeah, because you still have your OPT. As long as you have your OPT, you can work for any employer you like. Just because somebody registered you for electronic H1B lottery does not mean you lost your OPT status. Can employer Y file for my H1 even though I was registered in the lottery by X? No, but Y needs to register you again. And I've written an article on this. There is if you go to my LinkedIn page or immigration.com, my own page, you will see in my articles, one of the articles deals with multiple companies filing for the same individual. Can I ask X to not file an H1B after winning the lottery and use OPT as work authorization? Absolutely. You can. I'm applying for F1 OPT. Can I use my F1 OPT to work till September for Y? Then use H1B? Yes, absolutely. You can. Both an X and Y would want me to start. You can coordinate this with your DSO because they might change certain entries in your service record when there's a change of status, but I don't think this is a problem at all. Both X and I would want me to start around 15th of July. I would be using F1 OPT until my H1B gets approved. Yeah, all that sounds okay. All that sounds okay. All right, so are there any other frequently asked questions? No. Okay, let's go back and see what other non-frequently asked questions there are. So now we are on question number 4. So this is about filing for a green card and naturalization for our single parent. Do I need to be a green card holder or US citizen? You need to be a US citizen to apply for your parent. Which is the faster way to go? Consular processing or filing from here? I do want you to very carefully read the frequently asked questions on our website, immigration.com. I have covered this issue in detail, what the dangers of applying for a relative are when they are visiting the United States on a tourist visa. Do we need a lawyer? Not necessarily. The paperwork is straightforward, but if you have the money, I would say get a lawyer. Don't try to do it yourself, although I don't think a lawyer is necessarily needed, but it can help things. I see so many people making small errors and getting the case denied, which is not the end of the world, just wastes time. Next question. Filed. Oh yeah, this is the question I declined to answer. There are too many options, too many things going on. Set up a paid consultation. I won't be able to do it here. Okay, next is number 8. Incorrect priority date on receipt notice, job change after I-140 approval, and derivative spouse working under husband's work visa. I have an EB2 of August 2013 from one employer. I left them and joined employer B. In October, my employer B concurrently filed 485-765. Since EB3 dates become current, I have received I-140 receipt notice. Okay, now first of all, I'm assuming that employer B started your green card from scratch and then filed all these papers, and I think that should be fine. Question number 1, my attorney said, since it is a receipt notice, it won't affect my original priority date. Yes, I agree. This is not something you need to be concerned about, because if you are entitled to a priority date, even if your receipt or even your approval gives another priority date, that's okay. When you file the 485, which you actually already have, the government would automatically, they will screen it and they will know that you are entitled to an earlier priority date. But you can open a service request. It doesn't hurt. I don't see any problem with that. I don't think it's a big issue, but if you want to open a service request, you can. Upon receiving the GC EAD, I want to switch jobs. Job change criteria, same or similar job. Again, I have about 20 frequently asked questions on this. Review those. Upon my spouse receiving her green card EAD, can she immediately start working for any employer? Yes, because she's a derivative beneficiary. She actually has more freedom and flexibility than you do on her EAD. Okay. Next question, number 9. EB2 I-140 approved. Spouses EAD and H-4 extension in progress. Repercussions of working with another employer for more than 5 years. So you want to go outside the United States. I have discussed this again in frequently asked questions about 10 times in the last 6 months. There has to be a continuity in the intention to work for the employer and for the employer to have you work for them. If there is a good explanation why you need to have this gap and how the job continues to exist even in your absence, I think there is no problem with the absence, because ultimately green card is for a future job. Okay. After 5 years, if I decided to move back to the US, do I need a fresh H1B? Well, first of all, we don't know what the laws would be like in 5 years, right? If I decided to move back to the US, do I need a fresh H1B as my previous H1B would have expired? Absolutely. Absolutely, you will. Dropbox eligibility for H1B stamping. First of all, I do not know what the procedures in Australia are. I would have to contact the consulate for those. So you should do the same thing. Send them an email. If you get a visa stamping, a visa is a visa. It doesn't matter where it was issued. If the visa is stamped, you're good. It doesn't matter where it was from. Next question, number 12. I485 filed with I-140 EB3 downgrade, biometrics appointment, and possible upcoming travel to India. You filed the I-140 EB3 downgrade in first week of November, waiting on the biometrics, upcoming travel, planning to request H1B stamp. It's a very bad idea to travel outside the United States unless you have an H1B visa stamp already on your passport, or unless you can wait for the advance parole. If there's an emergency, you can try to get the advance parole expedited, but do not travel outside the United States unless you have a pre-existing H1B visa stamp or an advance parole. That would be my recommendation. Can the biometrics appointment be rescheduled? Yes. Can it be done by the immigration team without your signatures? Yeah, we do it all the time. You can't suggest a particular date for biometrics. You can request it, but I doubt they will accede to it. And we've done a reschedule twice in a couple of cases where people were outside the United States, Rahul. DUI and I-485 approval. Question number 13. I'm currently on H1B visa. I applied for I-485. Got a DUI, consulted me through a 15-minute phone consultation. I told you to get the certified copy of court disposition and a letter from criminal lawyer explaining this is a misdemeanor, and quote the statute. So with the first time DUI arrest in 2011, I have two questions. Does it affect my 485 approval? No. If it's a misdemeanor and the sentence imposed is less than 6 months, normally first time you don't get a sentence at all, you should not have any problem. I'm planning to convert from H1B status and start using EAD. I don't see any problem with that. But I always like to keep the H1B active. The simple reason is that if there's something wrong with the 485, that gives you the room to fight. Otherwise, if your 485 is denied, what is your legal status in the United States? Also, how can you continue working? They'll take away the EAD also. So I think having an H1B is a very good idea. Laura says, I'm currently on H1B with approved I-140 and pending I-485. I've got my H1B extension till 2023. Both stamps are expired, husband and I. We received EAD and advance parole valid till 2022. We want to visit our families in Europe in April and come back via Mexico as parolees. Yeah, that's fine. My questions are, since I may not have the time to renew my H1B stamp, will I still be able to get my stamp later on, like in December? Absolutely. Just because you return on advance parole, Laura, as long as you come to the same job for which you left, the one that you left, you are still considered to be on H1B. So if you're on H1B, you can always get visa stamping in December. I don't see any problem. If instead I have to renew my H1B visa stamp, can my husband come back as parolee? He can. Does this create any confusion with the immigration officials? Not at all. Does the H1B visa get cancelled if I enter as a parolee? No. I already answered that question. If you're coming back to resume the same job, you are still considered to be on H1B. Okay. So that's pretty much it, folks. It only took me like 20 minutes to cover these questions. Good for me and good for you. I will hopefully be able to talk with you the Thursday after the next one. I don't think I should have a problem that day. Good luck, guys, and always good to hear from you.